the illegal arrest. What I made.
Yes, sir.
Illegal arrest.
Huh?
The notices, 2 notices have been issued to him.
Yellide, sir. Notice.
He's only placed it, my lord, your lordship may see the
Where,
note.
no, where I asked you, notice jotege FIR complaint
Hakila.
copy, FIR, ellide.
Hakila.
Arrest is illegal, contrary to what I have written.
Not even crime number. In the notice. Hakila.
He is in police custody.
He's been produced today, man.
Huh?
He's been produced today before the magistrate.
Judicial custody ಕಳಿಸ್ಬಿಟ್ರಾ?
Illa. Today he's been produced.
then-
Need to be produced on or before 5:30 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Well, I'll direct his release now. It's totally illegal, sir. This is become terrible. ಸುಮ್ಮನೆ ಯಾರಿಗೆ ಬೇಕು ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀರಾ, ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಕೋಆಪರೇಟ್ ಮಾಡದೆ ಹೋದ್ರೆ ಮಾತ್ರ ನೋಟಿಸ್ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಏನ್ ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ? Where is the allegation ಕೋಆಪರೇಟ್ ಮಾಡಿಲ್ಲ ಅಂತ? The right of a citizen, liberty of a citizen is taken for a right like this. You issue a notice. If it does not come, notice ella idra, I have held that he need not appear. Enu kodalla, you just come. And police station is a happy place to come. The order shall be communicate the order now.
If be conveyed to the IO,
He ಹೇಳ್ಬಿಡಿ.
It's been remanded to judicial. If he's already been remanded to judicial custody.
If
not at as on now, I just called.
ಮಾಡಿ
File a memo. I'll file a memo.
judicial custody ಆಗೋಗ್ಬಿಟ್ಟಿದ್ರೆ then bail.
ಇಲ್ಲ. Even just a minute back, just.
Yes, then do it. Yes.
I'll communicate.
This court, therefore, the petitioner shall be released from police custody that he is in for the last 3 days, which prima facie is illegal. So this I want to write. I'll discuss ಮಾಡಬಹುದು.
The only problem for us is that since the court is directed to produce before the court before today, we'll have to produce and then release.
That's all right, but ಅದೇ ಮಾಡಿ in
ಅಲ್ಲ.
accordance, release in accordance with law. Yes.
Because otherwise, if you don't produce,
Sir, the liberty of a citizen cannot be taken away
understand,
like
I
this.
understand.
Just because you are a man in uniform, no, sir.
the notice
Not-
doesn't
So the
disclose.
notice should contain everything.
That's correct.
When you summon a person to investigate or inquire, it should contain everything.
Should have been.
It contains nothing and you arrest him. Total contravention of guidelines for Arnesh Kumar. Nothing is done. And who is this man? Who has arrested him?
Real estate man.
Real estate man. Allah, who?
I-
Police ಯಾರು ಅಂತ ಕೇಳಿದ್ದ. ಅವರು ರಿಯಲ್ ಎಸ್ಟೇಟ್, ಬಟ್ ಪೊಲೀಸ್ ಯಾರು ಅಂತ ಕೇಳಿದ್ದ.
No, I am not involved in real estate.
ನಿಮ್ದಲ್ಲ ಸರ್, ಐ ಆಮ್ ಟಾಕಿಂಗ್ ಆಫ್ policeman.
Okay.
Who is the one? SHO ಯಾರು?
I think so.
The SHO of so and so. ಯಾವ police station ಅದು? Shall be present before the court. Yes.
Present today.
Same.
He's present today.
Where is he?
I called him today. He's there in the.
There.
I'll say. There.
Is the SHO?
Inspector. Station.
ಕಾನೂನು ಗೊತ್ತಿಲ್ವಾ? ಕಾನೂನು ರಕ್ಷಕರಿಗೆ ಕಾನೂನು ಗೊತ್ತಿಲ್ಲ. ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಕೊಡ್ಬೇಕು? ನೋಟಿಸ್ ಅಲ್ಲಿ ಏನಿರ್ಬೇಕು? ಇದೆಯಾ? ಚೀಟಿ ವ್ಯವಹಾರ, ಚೀಟಿ ಇದ್ದಂಗಿದೆ ಅದು. Why should I not direct departmental inquiry against you for violating Supreme Court order there with all impunity? And you have arrested him. Why did you arrest him? He did not cooperate, is it? ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ? ಏನ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು?
ಆರೋಪಿಗಳು ಯಾರು ಸೆಲ್ ಮಾಡಿದಾರೆ ಅವ್ರನ್ನ ಪತ್ತೆ ಹಚ್ಚಬೇಕು.
ಸರಿ, ಪತ್ತೆ ಹಚ್ಬೇಕಾದ್ರೆ ಕಾನೂನು ಪ್ರಕಾರ ಪತ್ತೆ ಹಚ್ಬೇಕು. ಅದಕ್ಕೆ ಫಸ್ಟ್ ಕೊಡ್ಬೇಕು, ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ನೋಟಿಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಇರಬೇಕು. ಇವ್ರು ಯಾಕೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ಬೇಕು. ಅವ್ರು if they don't cooperate, then arrest. ಸೀದಾ ಅರೆಸ್ಟ್ ಮಾಡಿ ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ತಗೊಂಡೋಗೋದಂದ್ರೆ ಅವ್ರು ಕ್ರೈಮೇ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? Liberty of a citizen is so casual for you. This is ridiculous. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಸರ್ವಿಸ್?
15 years.
15 years. ಕಾನೂನು ಗೊತ್ತಿಲ್ಲ. What is this?
I told him.
ಏನ್ ಇವರಿಗೆಲ್ಲ ಓರಿಯಂಟೇಶನ್ ಕ್ಲಾಸ್ ಹಾಕ್ಬೇಕು ಮತ್ತೆ.
I told him today afternoon.
ಕಾನೂನು ಏನು ಅಂತ. ಅದೇನಿದೆ, ಒಂದು ಚೀಟಿ ಕಳಿಸಿದ್ದೀರಾ ಬಂದು ಅಪಿಯರ್ ಆಗಿ ಅಂತ. ಯಾಕೆ ಅಪಿಯರ್ ಆಗ್ಬೇಕು? Police station is a very grand place to appear. They feel rejuvenated going into the police station and coming back.
Take it up with the DG and
No,
this
the-
issue.
This I want, will direct it to the communicate to DG and IG.
Yes,
Not in this
Not in-
man's case,
generally-
but in general.
generally,
Why don't you issue circulars
I'll get it.
and guide every police station to do this?
I'll-
And I told judgmentally it should be issued, and what is done of that? Adenu ಮಾಡ್ರಲ್ಲ.
ಇಲ್ಲ, now
You
that
have kept it in cold storage. We will refer it to the contempt bench now.
the
We will direct the DG and IG to be present. Supreme Court has said yesterday, only when you call the top, the ball starts rolling. Anta. We will do that only. Otherwise, nothing is going to change here.
I will, well, have a, we'll see that something is done in that context.
It's not. Citizens' liberty cannot be taken casually like this. He may be a criminal or whatever it is, sir.
In accordance with,
In accordance with law, you should do it. This is not the way to do it.
we'll take it up with the DG and then.
Yes.
issue.
Hand delivery on memo.
ಕೊಡಿ ಅಲ್ಲ ಬೇಕಾಗುತ್ತೆ. Yes.
And your lordship's order details, I have got it. I'll just pass it on.
I have said all these three should be needed. Petitioner is before this court calling in question. Calling in question a crime in crime. The issue is not with regard to the registration of the crime, but what preceded the registration of the crime. It transpires that the petitioner was issued a notice under section 35(3) of the BNSS, the 41A of the earlier regime, the CRPC. The notice is indicative of the fact that it is blatantly contrary to law and what is held by this court. If a 41A notice is issued to the noticee to appear before the investigating officer, the notice must contain the crime number. The FIR should be appended to it as also the complaint, except in exceptional circumstances. The law is blatantly violated in the case at hand, as the notice does not contain even the crime number. This court has held that if the particulars are not appended to the notice, the noticee is not obliged to appear before the investigating officer, and the investigating officer cannot take coercive action on such non-appearance. The petitioner is arrested solely on the score, arrested on the ground that he has not cooperated with the investigation.
There is not even that allegation. In fact, in remand.
The petitioner is arrested in contravention of law. Therefore, this court is constrained to direct his release forthwith from custody from custody. Lest,
Be disposed of.
no, I want to observe something in this. This has become terrible.